Hello. The question we are discussing today is not a question that I have a particular answer to. It's more an interesting question for sort of an academic discussion. So if you have a similar situation on your own, it's better advised to consult a lawyer and bring up your own facts. So here is the fact pattern as we are discussing it today. Let's say some time ago, 2018, 15 years ago, one person gave money to another. The other one, who was borrowing the money, promised verbally, there was no written agreement to that, that the money would be returned from the estate when that person dies. So in his or her lifetime, the person will not return the money to the creditor, but after the death, the money will be returned. And to prove that intent, the borrower, the one who was taking money, left a particular stipulation in his or her will that when he or she dies, this debt should be paid back from the estate by the liquidators, executors. Okay, that happened. The will was signed, and then quite some time have passed, 15, 18, 20 years, and finally that person died. And now the debtor wants the money back, and preferably with interest, which through the years might become a hefty amount of money. And the liquidators, who are very often also heirs, might be hesitant to pay the money back. So what might be the argument for one side and for another? For the heirs, they might say that the prescription period, 3 years, have already passed, 3 years have passed, and there is no debt anymore. So when the will says that they should take care of the debt, their understanding of taking care of it might be exactly this, like legally we don't owe you anything and we inform you about that. Voila, we took care of it. They also might say that even if this debt is not considered to be a debt but a gift promised from the estate when somebody dies, that this gift, mortis causa, the gift conditional on the death of somebody, is invalid by the Civil Code of Quebec if that somebody is not a spouse of the deceased. So the liquidators might refuse to pay. The debtor, on the contrary, might say that even though the will was signed long ago, 15 years ago, so the admission of a debt technically was signed 15 years ago, the will became valid only at the point of the death. Therefore, the timing, the dating for the acknowledgement of a debt should be at this point when the will became valid, and therefore there is no prescription period ran. So the question here would be, like the legal question here would be, what's the actual date for this acknowledgement, for this admission? If it is then, 15, 18, 20 years ago, then it's prescribed. If it's now, when the person died, then it's not prescribed. Of course, there is another argument that the prescription period runs from the due date. When the debt was not paid on the due date, then there is a question of prescription. So there might be an argument that the due date was the date of death. But such a stipulation might not be accepted because it's a term and it's not a determinate term. Still, it might be argued both ways, actually. Also, the debtor might argue that the money was given to keep, and therefore the prescription period does not start even, because if the money is given to keep, not as an actual debt, then, or whatever valuable thing is given to keep, then the prescription period doesn't run. But again, the question would be how the creditor could prove that it was not actually a debt, that it was given for detention, as opposed to possession. As you can see, I'm not giving you any particular answer to that, and because it's all academic and of academic interest to me at this point. But a practical advice might be for a person who is finding or is going to find him or herself in the position of a creditor in such an arrangement. If you want to make sure that the money, well, as sure as possible under the circumstances, that the money is given back to you from the estate, you might insist that the stipulation is framed as a particular legacy, not as a return of a debt, not as a gift, but just a bequest going your way. And with that, all the questions of prescription would be no longer valid. But of course, the whole arrangement is quite precarious, because, as you know, the person might later change the will and then change it again without your knowledge, and eventually you could see that the borrower, the debtor, dies, and in the will there is no stipulation about such a debt. So in your particular reality, it will be, of course, a good idea to take care of some paperwork other than somebody's will. Because even if you get the stipulation about particular legacy in the will, the question of interest will be not taken care of anyway. This is the question I wanted to discuss with you today, and the point of particular interest for me was like when the admission, when the acknowledgement of debt is dated, when it was signed or when the will became valid. Everything else is just a surrounding fact pattern to bring up this particular question. Thank you, and have a nice day.